I'm Sean Kelly. I work on the Metro Act right-of-way issues for the Michigan Public Service Commission. The Metro Act deals with municipal rights-of-way permitting for telecommunications providers. I don't know if it wants to stay.
If you break that microphone, you have to buy us a new one. Just saying.
Perfect. Thank you. So obviously there's a lot of tie-in with my work with what Lindsay talked about with BEAD and the broadband build-out right now. I'm sure several of you are seeing applications from different providers dealing with telecommunications facilities or broadband facilities in the right-of-way. The Metro Act covers both above-ground and underground installations of telecom facilities. So a little bit of background on the Metro Act. It was created in 2002, created to streamline the process for obtaining access to the right-of-way. It created a uniform application process and permitting process for all municipalities. And when I say municipalities, I'm talking about townships, villages, and cities. The Metro Act does not apply to counties, so providers would have to obtain separate permits from counties. It was created to ensure the reasonable control and management of the right-of-way by municipalities. It was created to provide for common public rights-of-way maintenance fee applicable to telecommunication providers and to ensure the effective review and disposition of disputes under the Act. So, as Lindsay mentioned, when providers come into the state or new providers or providers are expanding, a lot of times they'll come to us and get a overview of what that application process looks like, what the requirements are, what they need to do. An example there would be a few years ago we saw a lot of the electric co-ops build out their broadband service. They would come to us first. We would walk them through what that permit application process looks like, what they need to submit, and the best way to go about that. A lot of these BEAD providers, we've had discussions with them as well, letting them know how that process works. Now, I'll give you just a general overview of that application process, and then we'll go through the slides to get a little more specific. So, if a provider wants to come into your community to install telecommunications facilities, they need to first complete the Metro Act application, which was approved by the commission. It's a standard form. They can obtain that on our website. They complete that application. They include a description of the project. They include a $500 application fee, and they submit that to your municipality, township, city, or village. It does not specify in the Metro Act who that needs to go to, whether it be clerk, supervisor. That's kind of up to you who reviews it, who signs off on that. I know some townships will have board meetings where it has to be approved. Some will just have a clerk sign off on it. There's no language in the Act that specifies how that has to be approved. The language in the Act does say that the municipality issues the permit, which I'm guessing if you're a smaller municipality, you don't get these applications very often and you're not really sure where those permit forms are located. They are located on our website. They are the commission approved forms that were created in 2002. If you go to our website, you can just download one of those forms, complete it, and issue it to the provider. That has the standard permitting language in there. So the two types of permits that you have to choose from, one is called a unilateral form, the other one's called a bilateral form. The main difference is that the unilateral form is for a period of 5 years. The bilateral form is for a period of 15 years, and then it would automatically renew for 3 more terms of 5 years if either party doesn't deny that or withdraw from that agreement. Those are the main differences. There are some other minor differences as well. We can get into specifics if you're concerned about that. So once that permit is issued to the provider, it's also up to, sorry, go ahead, did you have a question?
Well, I don't want to interrupt you, but
Go ahead.
you say the length of this agreement? When that agreement runs out, and you say it can be automatic, do they renegotiate that $500?
The language, thank you for bringing that up. So, the question is, do you renegotiate that $500 if that agreement runs out and they have to obtain a new agreement? I'm going to direct you to the language in the act and then also issue my disclaimer that I usually say at the beginning of all of this. I'm not an attorney. I'm not able to interpret the Metro Act for you. I'm also, the commission speaks through its orders, so I can't speak on behalf of the commission. Now, I deal with a lot of these issues. I've got a lot of background history in it. I can point you in the direction of this is the way it's been done before, this is the way it's been handled. If there are issues like this that come up, you should probably have your attorney review the language or come to us if there's some sort of dispute, and I'll get into the dispute resolution process later on. Now, the language in the act says it's a one-time $500 application fee. If you issued a 5-year permit that ran out and they did not submit a renewal request to extend that permit, typically I see municipalities don't require another $500 application fee. Typically I see that they don't. Now, as I said, I'm not an attorney. Your attorney may disagree on that. With the bilateral, it's for 15 years and automatically renews, so there would be no additional fees there. But the language in the act does say a one-time $500 application fee. So if that permit runs out, the 5-year agreement, and they come back a year later and say, we want a new permit, if you look at that as a new permit, you're going through the whole permit application process again, you may decide differently. So I guess that's the best way I can answer that.
Appreciate it.
So back to issuing the permit. Once that permit's been issued to the provider, the township is required to notify the commission that a permit has been granted or denied. We do track that. We keep records of that on our website. It's helpful, A, because there's a 45-day requirement for municipalities to respond to those applications. So we do track the length of time between the application and the date that the permit was issued or denied. The 45 days, there's been questions about that. Typically, both sides have agreed that that 45-day clock can start when there's a complete application submitted. So if they came to you and were missing the project description or were missing the $500 application fee, typically both sides have kind of agreed that that clock doesn't start until a complete application is submitted. Did you have a question?
Is there someone specific we need to send that notification to?
Yes, and I have information on the back side of the presentation on there, but yeah, okay. Go ahead.
When you send those notices to the individual townships, do they go to the clerks, and who do you find that's typically reviewing the applications?
So back to the last question first. He asked where to send those notices, and I have information later in the presentation that'll show you. There's a dedicated email address for the Metro inbox for the MPSC that you can email it or you can send a hard copy through the mail. And then you asked about who the applications are typically submitted to with the townships or municipality. Is that the question? So I'm sure in Berry County, as with all over the state, there's different size municipalities, and those offices are all different size with different numbers of employees. I've spoke with some municipalities in the UP where they have a clerk or supervisor that works 4 hours on a Monday and 4 hours on a Friday, and they're the only employee. We have some, in the city of Detroit where there's hundreds of employees. Like I said, the language in the act doesn't direct specifically where that's supposed to go. The provider should contact the municipality ahead of time, or check out the website and see, is there a building and department, is there a township supervisor, find out specifically who that should go to, and that's kind of up to you. There is no specific language in the act saying where that needs to go to. move along with the slides then. So the MPSC did create that permit application form. It's available on our website. There's a link to it in the presentation when I pass that along to you. Provider is required to submit that $500 application fee to each municipality. So if there's, city, village, city that they're going through, each one of those they need to apply to and send that $500 application fee. Must include route maps. That permit grants access to and ongoing use of the public right-of-way for the term of the permit. So they may come to you with a project right now through BEAD where they're planning on installing facilities in 6 months from right now. They would need to have a description of that project included with the application. Now, 3 years from now, if they go to expand on that project, they're gonna have to come back in with a new project description and submit that to you, and you sign off on it for that new project. So you have a chance to review those plans and say, hey, this works, this doesn't work, this is where this should be located, or it can't be located here. But they can go back in at any time during the term of that permit and do maintenance on those facilities that they have in the right of way. They have access to that. They are required to repair and restore the right of way after installation. There is some language in both the permit and in the Metro Act giving the municipality authority over that to hold them accountable for repairing and restoring the right of way. A municipality may require a bond as a condition of the permit based on the costs that it would require to return the right of way to its original condition. Talked about the 45 days for the review of the application. I have links to the unilateral permit, the bilateral permit. There is some specific, go ahead.
You talked a couple of times, you talked a bit about the denying permit. Can you talk a little bit about why a township or a municipality might deny?
So the question was, explain why a municipality could deny a permit. Typically, I've been working on Metro Act right-of-way issues for a number of years. Most of the time we see a permit denied, it is because of a lack of information included with the application and an incomplete application. And a lot of times you will see where a permit application is denied and then later approved once they correct that application or change the project description to meet the requirements of the municipality. There's no, I know in discussions that are going on right now at the federal level, some permit applications with municipalities can have that deemed granted language where if a township doesn't reply or respond to an application, it's automatically deemed granted. The Metro Act does not have deemed granted language in it. There are certain reasons, actually I think that was the next tab right there. Under sections 15 of the Metro Act says, this section shall not limit a municipality's right to review and approve a provider's access to an ongoing use of public right of way, or limit the municipality's authority to ensure and protect the health, safety, and welfare of the public. So I believe if you were going to deny that application, you would have to cite in there somewhere that you are denying it to protect the health, safety, and welfare of the public. I mentioned that the MPSC created the permit application forms and the permits. There was no commission-approved permit extension form that was created. The process that's kind of been created there is that a provider, say at the end of that 5-year term, will submit a letter to the municipality saying we would like to extend our unilateral permit based on the same terms and conditions that were originally agreed upon. The municipality can either sign off on that letter and extend that permit for another 5 years, or they can come back and say, please submit this documentation or whatever updated information you might need in order to extend that permit. So it's basically just a letter extending the original terms of the permit. We do have some sample permit extension requests on our website that AT&T and I believe Frontier have used in the past. And we also ask that you notify us of the permit extensions, just like you would the original permits.
Is there, I guess, the municipality can decide whether the terms of the contract, whether it's a 5 or 15? Or is that typically requested by the provider?
Good question. He's asking about kind of who decides whether it's the unilateral or the bilateral agreement. And again, this will go back to, I'm not an attorney, but the language in the act says the municipality shall issue the permit. So to me, that kind of reads the municipality can choose which type of permit they will sign off on. Now, a lot of times, especially in the smaller communities, providers will, along with their permit application, they just submit their preferred permit with that application because it saves the township a little bit of time and headache trying to figure out where to find that permit form. It's on our website. Just saves a little bit of time if they include their preferred permit. And that works for some, and sometimes we'll get calls saying they included a bilateral permit and we're not comfortable going beyond 5 years. Well, that's fine, just have those conversations with the provider, and typically that's fine. There is, I'll get to it later on, a dispute resolution process, both for the permit applications and for issues under the actual permit once it's granted. So if the provider had an issue where they said, we're not willing to accept a unilateral permit, we need bilateral, you could come to the commission for dispute resolution there. But I've never seen a dispute filed over an issue like that. Usually a provider's happy to get the permit, whether it's the 5 or 15, and they'll just deal with extending it later on. I will talk about the Local Community Stabilization Authority a little bit. So the Metro Authority was created under Section 3 of the Metro Act in 2002 when it was originally put into law. The Metro Authority was created to kind of deal with the financial side of this. They collected fees from providers and distributed those fees to municipalities. In 2014, the duties of the Metro Authority were transferred to the Local Community Stabilization Authority. The Local Community Stabilization Authority, or LCSA, they collect linear footage reports at the beginning of every year. So a provider must submit these linear footage reports saying how much footage they occupy in each municipality. The LCSA takes that information in, they will issue an invoice to the provider. The typical rate is 5 cents per linear foot occupied. That's what they collect from the provider. The LCSA then has a formula that was created by the Metro Act where they distribute those funds that they collected, 100% of the funds, back to cities, townships, and villages based on the linear footage occupied in those areas. And you will see those checks around June every year coming to your municipality, and those funds are to be used for rights-of-way purposes, which is very general, and I know we've gotten some questions on that in the past, but if you have specific questions about how those funds can be used, those questions should be directed to the LCSA.
Is there a report that comes with that funding that's sent out, you know, just to verify, hey, you got 10,000 linear feet that you need to pay for or whatever?
A report based on, like, telling you these providers are in your area. I don't know if that's automatically issued from the LCSA, but I've seen municipalities request it, and then the LCSA provide that information to them. So they can say, you have these 6 providers, and this is what they reported. So if you wish to confirm that those providers are reporting accurately, you can request that information from them. I'm not sure if that report automatically populates, but they will provide it. Okay. I didn't know what was included with the check, but I know that.
Nothing.
Okay. Okay.
So you can get that from who?
I'll share that information at the end of the presentation.
And if we want to know about a certain
Go ahead.
If you want to know about a certain activity in a right of way, like our fire chief has that those fees will cover dry hydrants in right of way.
The language in the Metro Act isn't real specific on that, but it does give the local community stabilization authority some authority on that.
So check with them.
Yes. For the fee sharing payments, basically a municipality must be in compliance with the act in order to receive those. They must be used solely for rights of way related purposes. We discussed that. On this slide, it does say that when you receive those funds and use them, if your municipality has a population of over 10,000, you do have to file an annual report on how those funds were used. If you're less than 10,000, you are not required to submit that report
The report to who?
to the LCSA. So this was, the email address is included on this slide that was asked for earlier. We use this Metro mailbox address here for questions, for submitting the permit notices when a permit's been put in place. So this is the address you can use, lara-mpsd-metro@michigan.gov. I do check that inbox, and then I can also give out my personal email. I believe that's on the last slide as well. So if you have questions or need to submit those notices, you can submit them to that address or to me specifically.
Do you typically send confirmation that you received that?
Yes. On our website as well, we have the application form, the commission-approved permit forms. We have a permit activity tracker listing all the permits that we've received on a quarterly basis for the year, and then on an annual basis going back all the way to 2002. We do also include some FAQs, frequently asked questions, and useful links there as well, some historical documents from the Metro Act, but that'll link to our website page. I believe it's on our last slide as well. So the MPSC has a role in dispute resolution as well. We've had a lot of success. It's very rare that we get a formal complaint or formal dispute. I do get several calls a week with questions about applications. Not as common, I'll get calls saying we can't resolve this issue or we need help resolving this issue. We've had a lot of success just kind of having a third party come in and say, well, this is the way the language reads, this is the way other municipalities handle it, this is the way other providers have done this, and we've had success resolving those disputes. Section 6 of the Metro Act does discuss a formal mediation process for permit-related disputes. Section 7 discusses a formal mediation process for right-of-way specific construction disputes, and there's also a formal complaint process in Section 18 to handle any violations. That section also allows the commission to issue fines if we were to find that a provider or a municipality was in violation of the Metro Act. This is very, very rare that we get any of these complaints, but we will get a lot of informal questions or, hey, can you help resolve this? And we're happy to jump in and, bring the two sides together. Sometimes it's just a three-way phone call where we're explaining what's in the act and how things have been done in the past, and usually parties can get it resolved. So yeah, I've included my direct phone number here. My personal address is the kellyS1@michigan.gov. I also have some business cards if you would like that information at hand, and then it'll be shared in the presentation as well. Is there any questions or anything I'm forgetting Metro related?
So you're talking about permits. This is only talking about permits. What happens if they come into your community, under the permit, they have to put the right of way back in the original condition? What happens if they don't? Do we bring that dispute to you then?
So the question was about what happens if they don't put the right-of-way back to its original condition. There is language in the Metro Act and in the permit application form that gives the municipality authority over that issue, stating that the right-of-way must be restored to its original condition, and then there's also the option of requiring a bond for the permit to be issued in the first place. And I guess based on my experience, the municipalities that do require a bond have been kind of burned in the past and seen issues, and then going forward might require that bond. But I have received questions saying they didn't restore the right-of-way, and unfortunately the act doesn't give the MPSC any authority there. It's the municipality's authority.
But at the same time, the provider is required to give you like a certificate of insurance. And at that point, you've got their insurance carrier, you can tap the insurance carrier on the shoulder and say, hey, this damage for us to restore it on that company's behalf is gonna be, whatever.
Well, the reason I asked that, we've had issues, a local Perry County company came through some years ago, and we have some sewer mains that aren't real deep, and they damaged those sewer lines, and we didn't realize it until,
At the time.
until 6 months later, so. I got, you answered my question on that, though, and I did see that we should require a bond. We just approved through the Metro Act some telecommunication coming into Hastings and doing every block in the city.
Yep. In case you couldn't hear the comment about the damage done to the sewer lines you said, which wasn't noticed until later on, but yes, one way to cover that is through the bond. It was also mentioned the provider must have insurance, be insured. They have to provide evidence of that insurance at the time of the application. So there are a couple options there to cover those issues. Any other questions about permitting? All right.
Sean, how long have you been working on Metro stuff?
I've been with the commission since 2008 and started wasn't too long after I started when I started working on the Metro Act issues. So just about every type of dispute or question related to it I've had in the last 15 or so years.
Sean's super good at municipalities have a question or have an issue. He's the guy to talk.
Well, and I do understand, especially with the smaller municipalities, a lot of times there's a lot of turnover, or people may handle one application during their term and then never see another one. So I'm happy if you call in. Like I said, I've got business cards. If you call in and have questions about it, I'm happy to answer any of those questions. We've tried to do, and Lindsay's done a good job of educating these providers that are being awarded money to come to your areas. We've tried to do some education and outreach there to make sure that they're following the proper process for obtaining these permits. So hopefully they're a little better educated as well.
We told them early and often, so if they're bothering you, knocking on your doors, it's my fault. I do have a correction to make, I apologize. It is 100/20 to be considered underserved, and it's 25/3 to be considered underserved.
This Metro Act thing, I was on the council when it first started, and I think it was like 2008. And back then, see, it was more aerial than underground. So now all of a sudden we're seeing more applications for underground. Even the telephone companies here, Verizon, all those companies, they were talking about coming in and putting small dishes on our telephone poles to get the signal out. And if you ever want to look at a mess, go down to that fire department, telephone pole down there. The first Metro Act that we approved, and we felt back in the day that we had to approve it. We couldn't deny it. And now what you're saying is we have a process we can go through to make sure things happen the way they're supposed to. But there's a pole down there, and I call it a garbage can on top, and it's leaning like this. It's not, so at some point in time, if you have to clean up an area like that, that's what my concern is.
So to your comments, the Metro Act does include a definition of what is considered telecommunications equipment that is allowed under the Metro Act. It does not include wireless facilities. It does not include distributed antenna systems. It does not include small cells, and it sounds like that's what you may have that was installed. You may want to check and see if that was installed under a small cell or wireless permit. Granted, I think that was 2018 legislation that created the permitting process for that, but those should not be installed under a Metro Act permit. The Metro Act also does not allow for poles. It doesn't cover poles to be installed, so they should be attaching to existing poles, not installing new poles. But there is a list, I think it's section 2K maybe has a definition of what is considered a telecommunications facility that's allowed in the right of way. Sounds like that's it.